Appeals of the Town of Orleans is hereby called to order. Present are myself, Michael P. Marnick, the Chair, Vice Chair Matthew Cole, members William McCarthy and Greg DeLore, who constitute a quorum. I understand that Rolf Soderstrom will, also a regular member, will be joining the meeting in due time this evening. The cases in order are number 1978, which was previously on the agenda, although I don't know if it was withdrawn and whether it was continued or withdrawn and resurfaced, but that is the application of the Orleans Athletic Association, and I propose to hold that for hearing later in the meeting. The second is case number 1981, the application of Gregory E. Lawler and Ann Logan. And the third is the application of Habitat for Humanity, a continuation of earlier proceedings in case number 1950 under letter of January 21, 2014 to the Zoning Board, suggesting by Lidara Zola, suggesting that the proposed change in the project is insubstantial, but nevertheless all persons who would otherwise have been entitled to notice were given notice by mail on February 18th. So the board will take that up after Mr. Zender, who I understand represents Gregory Lawler and Ann Logan. Attending on behalf of the board are the regular members Marnick, Cole, and DeLore, and associate member McCarthy, and the board secretary Sandy Stewart. Also in attendance is the building inspector of the town of Orleans, Brian Harrison. Are any members of the board disqualified by reason of a conflict of interest prohibited by law? No positive response. Have any members of the board communicated with the applicant or any interested parties? No positive response. Therefore, I declare that the members are indifferent. Therefore, voting on this application, the regular members in attendance, and do all persons intending to testify solemnly swear or affirm that the evidence they will give at this hearing before the Zoning Board of Appeals of the town of Orleans shall be the truth, the whole truth, and nothing but the truth?
I do.
Very well. Then, Mr. Zender, can you present this orally?
I will, Mr. Marnick, and thank you board members for hearing the application. This property at 7 Hammett Road has an existing boathouse structure that is shown on the plan prepared by David Little, and the plan is dated January 14, 2014, revised January 17, 2014, which should be the plan of record before you. The proposal here is very, very simple. And there's a second set of plans prepared by John Kelsey, who's also in the audience to your left of David. And the proposal is to maintain the existing structures, ground level and first floor level, and sidewalls and window structures, but to remove the flat slanted roof with a hip roof. This is done purely for the sake of aesthetics, and it involves no change in the interiors of the structure, the floor area of the structure, the location of the structure, the nexus to the ground. And if you look at the first page of Mr. Kelsey's plans, you'll see the calculations of square footage of the existing gross areas. You'll see the structure is 918 square feet. And the lower level, just so you know, the lower level is subject to some tidal action, so it's not really usable in any respect other than maybe to store some things that can get wet. And the upper level, which is really just one level of living area, 994 square feet, and there's existing decks and stairs of 541, which all will remain unchanged. So the reason we're here is because your zoning bylaw at section 164.21, which provides the setback and frontage requirements under Note C says that any construction in all zoning districts shall be set back a minimum distance equal to 1.5 times the building height from any coastal bank. Now, it does exempt boathouses from that zoning provision, which would appear to say we don't need to be here at all. However, this boathouse really is the nature of a studio. It's used, and it has been used as living space, including, as noted on the plan, a kitchen area. This used to be the house that Merv Hammett lived in, for periods of time. So I do believe that we're properly before this board, that it's not exempt from 164-21 Note C, but that I do believe that although it exists within the coastal area, it meets the requirements for a special permit as set forth in 164. I think it's 32, which I will not go into now unless the board wants me to. We've submitted written submissions that identify how we believe it meets all of those requirements. So if you have any questions, I'd like to try to answer them. John, the architect, can answer questions about the design itself. When you look at this, it involves an increase in height of something less than 4 feet on the overall height. It doesn't change the scale of the massing or location or use or anything of the structure, so we believe that it's properly before you for a special permit, and we hope you'll approve it. One final request through the chair is that because we don't have 5 members here, I really would beg the chair to indulge me to poll the board before a final vote to make sure that there either is or isn't a necessary vote to carry the permit. And thank you.
Very well. Need we be concerned with the alternative prayer for the grant of a variance?
I would ask that if, in fact, the board doesn't believe that it's properly before you for a special permit, or that you're not inclined to grant a special permit, that I be allowed to present on the variance question. If the board does, in fact, vote to grant a special permit, I would request of the board that we withdraw the request for the variance relief. And that's standard practice for me in cases like this, just to provide alternative means of relief.
Very well.
Yes.
Then, as we consider this, you are satisfied that the requirements for a special permit are appropriate?
I do believe that.
Okay.
Yes.
Very well.
Thank you.
Then, are there any questions of the applicant by any members of the board? Mr. Gold?
Were we provided information relative to the Conservation Commission approval?
No, it's been approved. I understand David presented and received the approval. I just don't have a copy of it with me. I can submit that for the file, but I understand that they approved the project with no unusual conditions.
Is that on record?
I don't believe it's recorded. Normally, they get recorded at the same time as the special permit. So, and my client was going to email it to me. It just didn't come through when I checked at the office tonight before I came over.
Could you talk through again the extent of what is being disturbed, the extent of the construction outside of just the roof structure?
I think John has got the model here. Are you talking about the construction itself?
Right.
Yeah.
How much of the existing building is being disturbed?
Maybe John can answer that question.
Sure. This is a very rough but to-scale model of the existing conditions, and that is the roof that we will be replacing. The concern of the client is he'd just like his boathouse to look a little less agricultural, if you will, and more nautical. I mean, it really is not as attractive as it could be. So the proposal is to remove the existing roof, and where the current existing roof meets the wall here, that plane will be drawn all the way around level, and the new roof will be applied to that plane. So and we have a larger overhang, and this, as Ben mentioned, does go up something less than 4 feet, but the actual eaves are going to be dropped considerably.
Could you explain to the board just structurally how they intend to frame that, though?
Yes. There'll be 2 trusses, which will go across here and here, which will meet the roof there. There'll be a ridge beam going between those two trusses here, and from the ends of the ridge beam, the hip beams will go down, and then the rafters will be spanning between.
So the upper story walls will remain intact and the
Intact.
and the decks will not be reconstructed?
From that point down, no change.
Okay, thank you.
Mr. DeLuca.
So there's no other renovations proposed to the building, other than the roof?
That's correct.
Would you mind rotating that so I can see the south
Absolutely.
end of it? No, the other way, sorry. That's the east, okay. That's
Yeah,
the
this
north.
is east, that's north.
Right. Could you rotate it so the south end's pointing towards me?
Okay,
Sorry.
the south end is here.
Yeah. I was just trying to figure out what you were saying about the overhangs. They look equal to me.
They are.
Oh, okay.
Currently,
So there's no overhang part?
well, there's a
Yeah.
3-foot overhang on the front and about 14 inches on the sides and the back. So we're establishing a common overhang of 2.5 feet all the way around.
Is this a primary residence or?
Well, the house it belongs to is not a primary residence, it's a rental property,
Summer
summer
rental?
essentially.
And it's going to be an open beam, kind of
Yes,
cathedral look?
yes, yep. The only interruptions will be the bottom chord of the two trusses that go across the space.
And when do they plan to do the work?
If-
Right away.
If it's if it's approved, we hope to apply for permit this week and start construction in April.
I don't have any more questions.
Very well.
Sure.
Let the record reflect that Ralph Soderstrom, regular member of the zoning board of appeals, has joined the meeting.
Yeah, better late than never.
Mr. Chairman,
Yes.
I mean, we can give Rolf a little time to
Yes, and your question.
catch up, and in my, just,
If you have an inquiry.
I do, if you would, sure. Mr. Zender, can I ask, I'm looking at your very helpful footnote about section 16421C,
Yes.
and it's more curious than anything at the last sentence where it says proposed change in roof style for that structure will intensify the nonconformity by increasing the roof height and thereby decreasing the allowed minimum setback distance. I'm just curious, how does the increase in height?
Well, here's why, is the bylaw says that that the setback has to be equal to 1.5 times the building height. So,
I see, okay.
so when you go up that 3 plus, I think it's 3 feet 8.5 inches, technically, you're increasing the required setback. Now, understanding this entire structure is seaward of the coastal bank anyways, so my sense would be, and I don't think I ever talked to Brian about this, I think any alteration to this structure sitting seaward of the coastal bank would probably require some review. I haven't thought that through because I didn't need to, but the short answer is, by going up, you increase the required setback, and since there isn't one already, you're making it more non-conforming, I think.
Also, just more curiously, given its current use, if you identified use as a boathouse, although for all practical purposes it's a studio
Yes.
function, is there any logic to sort of a change of use and occupancy to, I mean, since it isn't a boathouse, I'm wondering if just there's any benefit to the client of doing that?
Well, the use kind of is what it is. I mean, he's not proposing, Mr. Lawler's not proposing to change the use, primarily because when you go back, and I think that the prior permits were as part of the package submitted to this board, it was really approved as what they called, I think it was a bunkhouse, is what it was called originally. So it's not really a boathouse. A boathouse, as I think of it, we all have slightly different interpretations, I'm sure, is really a structure down in the water where you haul your boats up and you either work on them, restore them, haul them back out again. A lot of people call dwelling structures down to the secondary structures of the boathouse. This is really in the nature of a studio. It was originally a bunkhouse. So I don't think that the only change you could, I don't think there's any change you could really make to it, other than maybe convert it to a storage unit or something like that, that would really have any meaning to the board or to the owner. It's already been used for dwelling purposes. It's not a primary dwelling, but it's still used for people to stay in. It has a kitchen area. It has, some small partitions inside that set aside an area where you could sleep or do other things. But it's still essentially a studio structure.
And so either through prior decisions or under the zoning code bylaw definitions, it's habitable and usable and occupiable, notwithstanding it's being called a boathouse?
Yes, I think it is.
Okay.
Now, the original permission was for a bunkhouse. I don't know how the kitchen facilities play into that, in the sense that I do know by anecdotal history that, Merv and Pat Hammett used to own this house, and I know that when they were splitting up, and he was sleeping and living down there, and Pat was living up here, and up in the main house, and this is just, again, it's a small town, you know these things. I know these things. I don't know at what point it first came to have a kitchen facility in there. And I don't know whether or not, if we were to go back and try to isolate that out and match it up against your zoning code, whether it would in fact be a lawful dwelling unit. But because we're not coming to this board for a change of that use or a determination of that use, unless the building inspector believed that it was in violation and wanted to seek an enforcement, I don't really think that's,
You don't see the need to,
I don't see the need to
Okay,
do it. I mean,
that's fine.
Again, what we're asking you to do is, we're saying, look, the use is what it is, we want to make a structural change. We're not asking you to bless a use or to make a determination about a use. So, from what I understand, it's been used in this way for quite a long time. I've never gone down to match up various iterations of the zoning code against affidavits or about when it first became. I do understand from conversations with my client and other people that it's been the way that it's constructed, and by looking at the structure, you can tell that it's been used this way for a long time. But I don't know. But again, we're not asking this board to say that it's lawfully used for some particular purpose. We're asking you to just go have the structural change. It's clearly a 1 or 2 family residential structure. Clearly falls within falls in both the Orleans bylaw and 48 section 6 for special permits. So I hope I answered your question.
you did, and it was,
Yeah.
it was
I'm
more,
trying to be as sort of honest as I can about it. And just so you know, one of the reasons why there's a notation that says kitchen is I didn't want the board thinking we were trying to hide something. And I suggested to my client that we do identify that, just because I did want to make sure that the board understood what was out there. So that, we weren't trying to hide what's out there. So
sure. I was
Yeah.
sort of hypothesizing a role reversal and
Yeah.
whether I would,
Yeah.
but I'm not certainly asking you to do that.
Sure.
And I guess with respect to the special permit versus variance, obviously, with this, you'd be requesting the special permit run with the land then?
Yes.
So-
Yes, we would always request it run with the land. Yes.
So, otherwise, you'd probably prefer the variance, right?
No.
Except for
In my
challenge
experience,
issues
it's in 25 years, I think I've only had maybe 3 or 4 or 5 special permits that have actually run with the applicant, and usually where you see those are in commercial applications where somebody's opening a restaurant and you know them and you trust them, you don't know who's going to own it next year. P-Town, they do it all the time. But in this case, it doesn't make a lot of sense for Mr. Lawler to get a permit to alter the roof that only is legal as long as he owns the structure. It doesn't make sense. A variance would get us to the same place. And clearly, I'd rather have a variance than no special permit. But I think, again, the standards for the variance are higher and more strict than the special permit. And I do think this one is right in the ballpark for a special permit, so.
No other questions?
Thank you.
Thank you.
Yeah, thank you.
Are there any other questions from the board?
Yeah, I just had a quick question. Did conservation get into the septic issue, or will they had a cesspool or
I don't think so, no.
a septic system?
David Little, when we've been working working for the Hammets and then the Lawlers. When the property was sold, it was necessary to install a new septic system, and we went to the Conservation Commission for that purpose, and there is a pump chamber, or a pump, that pumps the septic from here up to the septic system well north of the property. So that went before the Conservation Commission, and then the roof change subsequently went before the Conservation Commission, and there were no substantive conditions placed on it.
So that was a period of years, though, in between those two
Yeah,
events?
many years.
Yeah,
But
so-
it was always recognized as a one-bedroom bunkhouse, and there were no issues at any of those junctures.
So the pump is pumping it up to a 10-year-old's Title V system?
Yes, there's a force main that pumps it up to a pump chamber and a septic tank.
Is that the dash line?
That's correct.
Okay, thank you.
I just want to follow up, is the capacity of the septic system a 5-bedroom or?
It was approved for what existed at the time, and nothing has changed since it was originally approved.
It is a 5-bedroom system. It's 4 in the main house and 1 in the bunkhouse.
Great, thanks.
Let the record reflect that the zoning board has received no correspondence relative to this application. Is there anyone present who wishes to also speak in favor of this application? Is there anyone present at this hearing wishing to speak in opposition to the application of Gregory E. Lawler and Ann Logan? No response, then if there's no further evidence to be presented, I propose to close the hearing for testimony, unless you have any further remarks, Mr. Zender.
No, Mr. Marnick.
It occurs to me that the use of the property really isn't before the board, except that under certain circumstances, in connection with the special permit, conditions are appropriate, and if the board heard some discussion that it was important for the owner or an opponent to deal with the question of use, then we could do that. But I didn't hear anything of the sort, so for myself, I'm ignoring the use, and you haven't insisted upon any condition preserving that use for kind of residential purposes rather than as a boathouse, regardless of what the original application was. We've got this one today. I consider that the application is appropriate for a special permit under Section 164-21C rather than a variance. And therefore, I am prepared to make a motion to that effect, if you're still looking to have the board poll, Mr. Zender.
I am. Thank you, Mr. Marnick.
Mr. Delory?
I'd like to ask I'd like to discuss it amongst the board first.
Well, we can do that. This is that time, yes.
Okay,
We can do it now, we're doing it now.
right.
You don't have to commit on, you can discuss it.
Maybe the attorneys on the board could comment on the applicability of special permit versus variance in this case.
We didn't really go down the trail, but we could, if we wanted to, consider it. Mr. Zender had at least submitted in writing a proposal where a variance could be allowed. The requirements are somewhat stricter, but generally have to relate to a hardship and/or a unique condition rising from, say, soil conditions or topography, which would set this piece of property different from any other properties in the neighborhood. Well, we know generally that there aren't two properties that are identical on the surface of the earth, even where the topography is quite level and not like this. But it seems to me that if we have the requirements for a special permit are met, Greg, that we should, and we are, at least in my case, I'm more comfortable in dealing with that, although we've granted variances in the past. I thought that's where I'm coming from.
I understand
You
that.
see.
Yeah, I do.
Otherwise, we could do the calculation and show how that lot topographically, the bumping up of the height of the roof, and you would probably be far more experienced than I would be as to how that affects the proportions and percentages, and that's what Mr. Zender has done in the alternative. If the sense of the board is that we consider this as a variance application, then we can do that, and we'll consider it. We'll rule accordingly.
I wanted your sense of if it would qualify for a variance versus a special permit, which was more appropriate? Or did you already answer that?
Mr. Zender has proposed that it is more appropriate that he would just as soon have a special permit granted, and his whole pitch and his presentation has been devoted to that. I think it's myself that it is appropriate. I have reviewed the alternative, and I think that if the board agreed that there are certain conditions that are unique to this parcel, and that a variance might be appropriate also. It all depends on the sense of the board, though.
Mr. Chairman, I guess I'd add that while Mr. Zender appropriately asserts in the alternative argument for the variance of the unique topography, the question would be, given the nature of what's proposed and its relationship to the topographical criteria, if indeed we can make the findings for a special permit, I think that we don't have to go down that road of whether or not it would meet the test of a variance, and if it runs with the land, I think it gives the owner effectively the same protection. And last but not least, if one were to challenge a variance, it's assuming standing and other things are achieved, that's a much more precarious position to then prove that it literally meets the variance requirements, whereas the special permit, I think, reduced to its minimum would be a benefits burdens type of analysis, and therefore much harder for an appellant to overturn.
I guess my question is, why was it presented, why were the variance arguments presented at the same time? Is it that close of a call?
Well, I can't, I couldn't answer.
In the alternative,
Yeah.
right?
Just generally speaking, we generally apply for variances in the alternative as a matter of just essentially avoiding malpractice, because it's possible that a board will look at an application, disagree with me, and say, this doesn't fall under one of our criteria for a special permit. So then we're faced with either reapplying for a variance, or, so we always apply for the variance where we think that there are some credible grounds for a variance as an alternative, We don't hope that the board will seek to treat it as a variance, because I think Mr. McCarthy set those reasons out very well. But it's really just, it's just sort of a belt and suspenders approach to applying to the board. It wasn't any argument that the variance is more appropriate.
No, I know your argument isn't the variance is more appropriate. I know that.
I don't think it is, so,
Okay, thank you.
thank you.
We don't see commonly an application which seeks relief under the special permit sections or variance, but we have occasionally done that, and I would say within the past 4 or 5 months, we did grant a variance, and we decided that at the time of the hearing, that was more appropriate. So an applicant, without asking for it both ways, acts kind of at their peril. You know what I mean, Greg?
Okay, thank you.
Well, in the sense of polling the board, I'm in favor or support.
I think 164.3C2 by my read and the read of the case, the special permit would be appropriate, and generally I'm in favor of the application based on what we've learned.
The way I understand it, we're just looking at a change in and the illustration is absolutely brilliant. We don't have 3Ds too often, two models in front of us, but what's happened here is the existing height of that roof is being raised by 3.7 feet. Is that the bottom line?
3 feet, 8.5 inches.
Yeah.
No visual impact on anyone else, right?
I can't see it.
Well, a bunch of
especially
people
with
can see it, for sure, but it's not degrading the structure by any means.
Or impairing others' views.
I don't see how that would happen. It's way down.
I didn't think so either, I couldn't figure
It's
out.
way down, right on the water.
Sure.
It's a pretty steep hillside.
Do you have a sense of your feeling concerning the application now, Mr. Delory?
Under the special permit criteria, I'd be in favor.
Very well. Then, members, following public deliberation by the Zoning Board of Appeals, a quorum of qualified members being present and voting, and based on the application of Gregory E. Lawler and Ann Logan, filed February 7th, 2014, and based also upon the site plan out of the application, dated January 14, 2014, revised on January 17, 2014, entitled Site Plan Proposed Boathouse Renovations, prepared by Ryder and Wilcox, Inc. And based also upon the 3 pages of drawings entitled Lawler Boathouse, and 2 pages existing conditions, the 3rd proposed revisions dated various dates in February 2013 and December 2013, is labeled, and the order of conditions of the Orleans Conservation Commission, which is not part of the record but will be attached as part of the file. I move that the board adopt the following findings of fact. The subject property, known as 7 Hammett Road, Orleans, is shown as parcel 11 on Orleans map 82. The
present use of the property is a single-family residence with a separate freestanding structure entitled on the site plan as existing boathouse. The proposed use of the property is the same as the present use, except that the form and style of the roof is proposed to be replaced. The proposed use will not be detrimental to the established and future character of the neighborhood and will be in harmony with the general intent and purpose of the zoning bylaw. Additionally, the alteration and reconstruction will not be substantially more detrimental to the neighborhood than the existing structure. 6, the site is adequate in terms of size, that is 76,230 square feet, of which 45,990 square feet is buildable upland and suitable for the proposed use. 7, the proposed use will have no negative impact on traffic flow or safety. 8, the proposed use will have no negative impact on the visual character of the neighborhood. 9, the proposed use is isolated from and will have no impact on the method of sewage disposal, source of water, drainage, or water resources. 10, utilities and public services will be adequate for the proposed use or change in use. 11, noise and litter will not be increased after the construction of the proposed use. 12, there will be no adverse impact on groundwater quality and recharge volume, and the water quality of coastal and fresh surface water bodies. The proposed alteration does not involve any variation or alteration of the footprint of the present structure. Do I hear a second to the motion?
Second?
Is there any discussion on the motion, gentlemen? Then all those in favor
Aye.
and opposed? Motion carries unanimously. Therefore, based on the findings of fact, I move that the board grant a special permit pursuant to Orleans zoning bylaw, section 164-21C and 164-3C, to replace a roof on a pre-existing non-conforming building to run with the land. Do I hear a second to the motion to grant a special permit?
Second.
Very well. Any discussion on the motion? All those in favor?
Aye.
And opposed? The motion carries unanimously.
Thank you, Mr. Monahan.
Thank you.
Thank you, board members.
Thank you.
Motion to withdraw the request for variance?
Thank you, Sandy. Yeah, I would ask the board to consider withdrawing my request for variance.
And the withdrawal is granted with prejudice. The next order of business is we're to Habitat and Interior. Could be excused, is that okay?
You have it next?
David? Yeah, I think we ought to. Do you mind?
Mr. Chairman,
Yes.
you, aren't I next?
I was going to take the application of Habitat, then the Orleans Athletic Association.
Reason being?
We want a threshold determination as a point of order as to whether Habitat is in.
No, I'm just wondering why, if we have a quorum now, why I've already been put off for 2 meetings for lack of quorums, why I'm being.
You're not going to be put off. You'll be heard tonight.
Okay,
We're going to hear Orleans Athletic.
okay, thank you.
I'm going to call now the case number 1950, the application of Habitat for Humanity. This is a previously granted decision under Chapter 40B. The foundation of this application is based on a letter request of the applicant dated January 21, 2014, under the signature of Lydia Arzola, who is present. On or about February 18th, 2014, all abutters who were previously notified of the hearing under Chapter 40B conducted by this board were also notified of the hearing tonight. The letter, and Ms. Zola, you will speak for yourself, but members of the board, there's a threshold decision to be made. Whether the change concerning Lot 1, which is the building which is now expected to be raised, and specifically the changes in access to that, whether it's from Bevan Way instead of from the existing driveway off of Namscayket Road, is a substantial or insubstantial change. If the change is insubstantial, then the board can consider it and approve it. Otherwise, we will continue the hearing on the original application, all parties having been notified. So that's the, I'd like to hear from Habitat as to why these changes change, how many changes there are, and their gravity, and why you claim that those changes are insubstantial and that our approval is almost ministerial.
My name is Warren Brody. I'm an attorney for Habitat for Humanity of Cape Cod. I'm also a member of its board, and I appreciate the opportunity to address you. The issues that are raised here are, to look at it from a broader perspective, Habitat was granted a permit under the Comprehensive Permit Statute, Mass General Laws, Chapter 40B. Always we had contemplated a 6-lot development, if you will, 6 building units, 6 dwelling units. With the existing unit on Lot 1, we were encouraged to and did engage in the process of trying to find someone to renovate it, to do an historical rehabilitation of the unit. We issued requests for proposals. We engaged in negotiations. We hired a consultant. Long story short, we didn't find anyone that really wanted to do right by that particular structure. In the interests of affordable housing, it's going to make another affordable unit available for a deserving family in the area. That being said, existing plan that was approved showed the access to Lot 1 being a driveway coming from Namscakett Road, where it always had been. We feel that it would be far better to create a driveway into Lot 1 from the newly constructed Bevan Way, and that way to include this unit more integrally into the other 5 units of the housing development. It makes perfect sense to do it that way. And we would therefore abandon the existing driveway that's there in connection with the raising of the structure that's on the lot. So all we are really asking for is a change in the plan that would allow us to construct a driveway from Bevan Way onto Lot 1, rather than using the existing driveway coming off Namscakett Road. Makes more sense, probably from a traffic perspective, is more sensible, and again, integrates that lot into the rest of the community of the other 5 houses. At the same time, there is one other minor aspect here, and that is Lot 1, by virtue of the construction of Bevan Way, has become a corner lot, and therefore technically is required to comply on both corner lines with the existing frontage requirement of 150 feet. And it doesn't. It does on Namscakett Road, but it doesn't on Bevan Way. So we would simply request that the plan, which has already really been approved by this board with that dimension, recognize that the dimension is not in conformance with the requirement of the 150 foot frontage requirement of section 164.21.A. That's really it. And I wish I had a model, because that was really fantastic to have that model.
Well, what you're talking about is, here in this case, is relative, it's just two-dimensional. So you're looking for what, you were given waivers as to lots 2 and 3, in one case 40, for frontage, from the 150-foot requirement, in one case 41.2 feet, and the other 36.94 feet. And what kind of a waiver are you looking for here?
It would be a waiver with respect to the frontage on Bevan Way.
Yeah.
It's 104 feet and 15/100ths,
So we,
and that is short of the 150 that is required by 164.21A.
so we need to do the subtraction here, which is 145.85.
5.85, no, yeah, 45.85.
45 feet,
45.85
45.85 feet.
Is the difference to
That's the
150,
waiver
yes.
that you need, which is in proportion, in relative proportion to the 2 other waivers.
Yes, and I suggest that the approval even of that is insubstantial in light of the approval of the overall plan by this board a year ago, October. All that's changed is that we are now raising the existing house, and we're now focused on the dimensions of that lot more than we were before, and on the driveway that will now be included from Bevan Way.
So the real plan change is the driveway.
Yes. That is the only
The lot
plan
lines don't change. The existing house is a 3-bedroom house.
Yes?
I believe that there was some discussion about how many bedrooms, because it was a very old house, but what the comprehensive permit specified was that if an affordable house were to be built on Lot 1, that it would be a 3-bedroom. So that is already in the comprehensive permit, that it's limited to 3 bedrooms.
And that's what's shown on the plan that's before you.
And that was always part of the deal.
Well, unless we could have found someone that would be willing to do the rehabilitation properly, but we didn't.
Are we open for questions now?
Yes, yes. I was provoking them.
Could I ask
Greg?
one just
Go
on
ahead,
a
Bill, go
follow-up?
ahead.
I'm curious, and have to say I'm reading it for the first time, but in the footnote 1 to 16421, referring one to 16422H, I'm just curious if with reference to the turn from Namscachet onto Bevan, is there any way that subsection H offers you any relief from that frontage requirement?
I don't know the answer to that, frankly. The radiuses, as shown on the plan, were previously approved as part of the 40B permit.
I guess in part, is it, pardon my lack of recollection, but is it ultimately a dead-end turnaround?
So a cul-de-sac, yes.
It is.
Unless I'm missing something or not reading it correctly, maybe,
I have a question about the plan. I've never seen the plan. Did you submit a plan along with the application, plot plan? You submitted that?
Yes, that should be before you.
I've never seen it.
I got one
some
copy.
on the side, is there?
What's that? What?
Can you tell us?
We got one
Is there
copy.
100
One copy for all of us?
120 feet?
We
so-
got one copy. So yes, that would be one for all of us.
Oh, I've never seen it.
Apologize.
Is this the plan referred to in your letter, Mr. Brody? Site plan 31, Namscachet Road, dash Lot 1 by East Cape Engineering, dated November 20, 2013.
Yes.
Okay. That'll be part of the record. I haven't seen it.
Have you seen it, Michael?
No, I don't believe I
I
have.
don't think anybody's seen it.
Did that look like-
I didn't realize I had the only copy. I have seen it.
You've got the only copy. I emailed last week. I said, where's the plot plan? What's going on? I don't know.
It's 34 feet
Yeah,
apart.
and I pardon for raising it, my colleague just pointed out that the arc, 50-foot arc requirement is shy about 15.70. But I was looking to find a way, as they say. Do you want to look at this?
I've got a reduced version.
Okay.
Yeah. So what we're looking at tonight is not the issue of raising the house, which is actually specified in the agenda for tonight, that's what we're supposed to be looking at. But the application is just for the driveway.
The raising of the house is specifically dealt with in the comprehensive permit as an eventuality if we could not find a developer. So that's behind us. The driveway is what's before us tonight,
Okay.
and not the shape of Bevan Way or the radii to Namscachet Road or any other aspect of the site plan which has been previously approved. It is all about the proposed driveway. And as a result of perhaps an oversight, we had not addressed the need for a waiver with respect to the sideline, now the frontage, on Bevan Way of Lot 1, which is less than 150 feet. That is all that's really being asked.
And question is that substantial change?
Yes, and if you look at the guidelines that are given in 760 CMR 56.075, which are recited in Ms. Zola's letter, there are 10 different criteria, 5 that result in substantial changes and 5 that do not. And it's hard to, there's nothing in the 5 criteria delineating a substantial change that seemed to apply here. And frankly, nothing in the others that seems to apply either. There's nothing requiring you, there's nothing in the regulation requiring you to find that this is a substantial change. It is not an increase of more than 10% in the height of the buildings, number of housing units, reduction in size, change in building type, or a change from one form of housing tenure to another. Those would be automatic. That would require you to find that this is a substantial change. And with respect to those things that are not substantial, they include a reduction in number of housing units, a decrease of less than 10% in the floor area of individual units, change in the number of bedrooms, so long as the overall count doesn't change by more than 10%, a change in the color or materials used, or a change in the financing program. There is nothing here that really addresses the issue. And all we're saying is you need a driveway. It can be from Namscakett Road. It can be from Bevan Way. We think Bevan Way works a lot better.
Are you going to eliminate the driveway from Nantucket
Yes.
and then landscape it over so it was never there?
Yes. Would be eliminated.
Both? Both existing curb cuts that are shown?
I think one's dirt, isn't it?
This, is it here?
Yeah. It's been a while since we've been to the house site. We've been to the Bevan Way more.
I think you would normally be drawn to pull in here, although this is shown more substantially on the plan. So I think just to clarify Greg's question, it would be helpful to know if both of those are intended to be abandoned.
Yes.
Yes.
Our intent is
And-
that access would be off Bevan, and we would, want that to have the feel of the landscaping in front. We would abandon both access off Namscakett.
So there wouldn't be any pull-in auxiliary things coming in off of Nantucket?
No, other than the water service. And there, we have a question there as to whether it's more advantageous to bring it in from Bevan or not. But that's underground.
Well, see, the concept here is the overriding concept is to develop a cohesive and consistent neighborhood. And what you've done is, you've really continuing to advance that and taken care of an oversight which was caused by the inability to rehab Building 1. So what you're doing now is by allowing people to have access to this new structure off the same new road that their neighbors are, you're advancing that whole cohesive neighborhood, and that was that was the brainchild from the very get-go, the way I figure it.
I agree, and also there's another minor aspect of this, and that is that all 6 units will participate in the homeowners association, which is responsible for the maintenance of Bevan Way.
And no one would, the owner of Unit 1 would have no psychological objection to that, because that's how they're getting in and out of their property.
Exactly.
So,
Mr. Chairman, could I offer just a query? I'm wondering, in the course of exploring the corner lot double frontage issue, did you find anything helpful that differentiated what I assume Bevan Way is a private way
Yes.
from a street? And I'm kind of a stream of consciousness, but when I look at the corner lot requirement, shall maintain front yard requirements for each street frontage. And I'm wondering if there's a nuance or a differentiation. Could I ask Brian if, in his review of things, do you make any differentiations between what street?
Sure. To me, it doesn't make much of a difference here. The house exists. I don't think that you've already approved it. The only thing you're changing here is the driveway. The frontage you're not going to change whether they rehab this or they build a new house there.
What about the access and the fire department and all that? Does that add traffic load to significant?
I think it's de minimis. As long as we get to the house, this is going to be an issue.
But if I'm correct, before the change, the corner lot issue didn't come into play.
Now, with an existing house, you've already approved the plans and having a house already there. The only thing that's changing is we just tearing that one down and building another one, so the only thing other than that is just a driveway. I mean, I don't see the frontage as being an issue myself.
Well, that's what I'm hoping we can, if we all agree, but I was looking for a basis on which to hang that, so that's some relief of whatever for the lack of frontage length?
Be a waiver. It's a waiver. It would be, in other words, if this situation had been conceived at the time of the original hearing, we would have been asked to provide a waiver as to Lot 1 of 45.85 feet as for frontage. And I think that's, the question is here is, first is whether that kind of addition of that, modifying the special permit to add that waiver is substantial, and if it is insubstantial, then to go ahead and add that to the special permit. I think that's what Habitat wants, what was looking for.
So the lack of sufficient frontage would be deemed a waiver?
Yes.
Okay, I mean,
Yeah,
part of what I
because
was...
the way 40B is, and you probably know it much better than I do, but 40B trumps, it almost trumps zoning, so what would ordinarily be a serious arithmetical variation is no longer of great importance when you consider the whole cohesive neighborhood. You know?
Yeah, if we rule that, the change is insubstantial, end of issue, isn't it?
Well,
I think so, but to be thorough, I think we'd also add that what the proposed change is.
Of course.
To give them that waiver, so at least it's a matter of record.
Okay.
But otherwise, to some extent, if it's substantial, I think, Ralph, we have to have a brand-new public hearing. And I don't know how much of that can be opened up, but we're prepared to do that tonight if we determine that it's a substantial change.
I think it's insubstantial.
I agree.
and quite frankly, I agree as well. One of the reasons for pursuing it was thinking prospectively for a future conveyance, and could it, if the waiver kind of blesses the insufficiency of that dimensional requirement, such that a future conveyance doesn't trigger a zoning nonconformity, would be I'd want you to have that insurance, so to speak, by however we...
It's important because we're talking about access to a public way here.
Right.
You know?
But with respect to that unit itself.
That's right, with respect to that unit.
So if, I'm not as steeped in 40B as perhaps I should be, but if the insubstantial and a waiver and notation specifically of what it is, if your feeling is that gives you all you need, and the board feels the same way, sounds good to me.
Well,
Excuse me.
yes.
Oh, I would argue that it's the issue of the frontage on Bevan Way is truly insubstantial because the plan with that dimension on it has really already been approved. It was approved as part of the 40B permit. We're just bringing it to the board's attention because of the somewhat new status of Lot 1. Otherwise, we wouldn't be dealing with it.
Before we proceed, is there anyone present wishing to speak in addition to, in favor of this application or against it?
I'm Julia Enroth, Chairman of the Community Preservation
Yes, ma'am.
Committee of the town, and we were here when the original application came in and supported it then, and we are supporting this change. In fact, we have voted to additional funds to help with the new house that we hope to see go on that lot.
Very well, Ms. Enroth. Thank you for speaking and being present.
Is there anyone else wishing to speak relative to this application? Then I think we can close the hearing on the question of your letter request, Mr. Brody. And is there any discussion by the board? I'm inclined to, based on the provisions of Code of Massachusetts regulation, which gives some guidance as to what is considered substantial and insubstantial, based also on the common sense that Mr. Soderstrom brings to the meeting, and as to what is substantial and insubstantial. I'm thinking that this request for a waiver of 45.85 feet, a zoning waiver from the frontage requirement under section 164.21A is insubstantial, but ought to be made a part of the record of the originally granted special permit. Is there any other commentary?
Is it just the lack of frontage that we need to deal, along Bevan that we need to deal with, or do we also need to deal with the dimension along Namscaken?
No, I don't believe so. I believe we have substantially over 150 feet there.
Oh, okay, okay.
Nor does the proposed driveway is not controversial either.
Thank you.
Oh, I jumped in on Bill's question to Brian. Brian, it's a private, Bevan's a private road, and that the emergency vehicle access, there's no issue there. Did it have to go through site plan review to get all that sorted out?
I don't think it's that big a deal. I think as long as you have a driveway and have access for vehicles to get in there, probably sufficient. I mean, I just think it was like Panhandle Lot. I mean, no much different than that. It's just kind of, that's it.
Okay, thank you.
Very well, then, members of the board. Following public deliberation by the Zoning Board of Appeals, a quorum of qualified members being present and voting, and based on the letter request dated January 21, 2014 of Habitat for Humanity of Cape Cod, based also on the site plan entitled Sewage Disposal System Upgrade drawn by East Cape Engineering, Inc., dated November 20, 2013, that the zoning board finds that the proposed change to the frontage as to Lot 1 is insubstantial, and that the initially granted decision in case number 1950 dated dated on or about October 17, 2012, be modified by granting a waiver from section 164-21A, the frontage requirement of 150 feet, the waiver as to Lot 1, 45.85 feet. Do I hear a second?
Second?
Is there a discussion on the motion?
Should that motion also include an amendment to the documents listed to include the new site plan, or do you want to address that separately?
I think it was contained in the motion.
Okay,
I
I missed
referred
that, I
to
apologize.
the letter and the site plan,
Okay, thank you.
because the board used it tonight.
There's a motion and a second.
Is there any discussion on the motion? I'll call for a vote. All those in favor?
Aye.
And opposed? Motion carries unanimously.
Thank you.
Thank you, Mr. Chairman, members of the board, Madam Secretary.
Thank you. Let the record reflect that the, will also include, the record will include the draft minutes of the Community Preservation Committee dated September 6, 2013, and the previous meeting of the Orleans Historical Commission dated March 16, 2012. Documents which had been circulated in connection with this application at one time for the meeting. Thank you, Ms. Enroth.
Oh, can I say, question, was it purely a question of expense to try to restore the existing?
I believe
More
they-
complicated.
Yeah, if we looked, I mean, we really spent the entire year of the demo delay. We issued 2 RFPs. It was a very expensive project, and it's a tough nut. Historic rehab is not
Sure.
inexpensive. It would have been beautiful to find, a nonprofit developer who wanted to, and we just couldn't.
It wasn't feasible.
Yeah.
I guess. We
Good
should
luck.
try.
Good luck.
Thank you.
Mr. Little will be joining us to present on case number 1978, but before that, it would be appropriate to consider and approve the minutes of the February 19th, 2014 meeting
And January 15th.
and January 15th, 2014 meeting. Are there any amendments or comments concerning those minutes? Then I'll entertain a motion to approve the minutes of those 2 meetings.
So moved.
And a second?
Second.
Any discussion on the motion? All those in favor?
Aye.
And opposed? None. Motion carries unanimously. I have received from the Massachusetts Department of Housing and Community Development notice of a Citizen Planner Training Collaborative to be held at Holy Cross College on March 15, 2014. The conference is entitled Advanced Tools and Techniques for Planning and Zoning. Anyone who is interested in this can let me know.
Is it a case where there's a fee?
I didn't look at it. There's usually less than $50, I think. Very well. Do you have anything to bring before the board, Mr. Cole? Very well. Then we'll consider the application of in case number 1978, the Orleans Athletic Association for a variance. Mr. Little.
Thank you, Mr. Chairman.
Let the record reflect that Mr. Cole is excused from the meeting.
David Little, representing the Orleans Athletic Association. The OAA is responsible for maintaining the dugouts, the buildings in Eldridge Park. Even though the property is owned by the town of Orleans, they maintain the structures. And this will be the 3rd time that I've represented the OAA before the Zoning Board of Appeals. And what we are asking for this evening is a variance to construct additions to and to renovate the existing souvenir shop and press box. I've provided the commission with photographs of what the new press box would look like. It's been designed by Rich Morangel, a local architect. The design is in keeping with the design of the dugouts. that Rich also designed, and this board also approved, granted relief for their construction as well. So if you notice on the site plan, the detail that I provided you, the addition is proposed to go in a northwesterly direction, further away from Route 28, but closer to the common property line between the Orleans Middle School and the ball field owned by the town of Orleans. What I think is important to point out here is, for those of you that have been to the ballpark, the property line that separates the town property and the middle school property is in no way visible or represented by anything on the ground. It's where the patrons go and everyone sits to watch the games is here, and no one would ever even realize that there's a property line that exists there. So that being said, and to try and keep things moving quickly for you this evening, we are increasing the non-conforming nature of the structure to the property line by going from 19.2 feet to 10.6 feet to allow for the expansion of the press box and souvenir shop. And it's not a residential structure, it's not a pre-existing non-conforming commercial structure. It has always received relief from this board when work has been done on it in the past, so I have applied for a variance to that end. And the variance, which to me seems obvious, is definitely owing to both the shape and topography of the property. The ball field, because of the ball field's configuration, there's no physical place other than where the announcer's booth is now than to keep it in that location. There is no viable alternative other than to perhaps redo the entire ball field and turn it 180 degrees, which is not feasible. And secondly, topographically, we do have an issue with the topography. There's no other place to put it that is flat and would work out well for announcers, because obviously they have to be behind home plate to view what's going on and announce it appropriately. So that being said, I do believe that we comply with the variance criteria for this project. This venue offers thousands of people enjoyment during the summer months. I think that it's evident by the numbers that go to see the ball games that this is an improvement that will not only benefit the town, but it'll help out the OAA. The design of the building is going to be such that handicapped people will be able to be afforded the opportunity to do anything that the announcers do upstairs down below. I don't know if you've ever been to any games, but there's the audio-visual people and the internet-connected people sit here at tables, and it will become a handicap-accessible structure as well for the purposes of offering anybody the ability to do announcing. They would be able to do that. And then thirdly, hopefully, Mr. Marnick, you have a letter in the record from John Kelly on behalf of the selectmen. If not, I'll submit one to you. And I will read it into the record. Michael Marnick, Chairman, Zoning Board of Appeals, Town Hall, Orleans, Mass. R.E. Eldridge Field Application, Orleans Athletic Association. On behalf of the Board of Selectmen, please accept this letter in support of the application of the OAA for a variance to renovate and expand the existing announcer's booth and home plate shop building at town-owned Eldridge Field. The present building is too small and does not meet current Architectural Access Board guidelines. The OAA is proposing to renovate and expand the building at no cost to the town and maintain it on a yearly basis for as long as the Orleans Firebirds baseball team continues to use the facility. The Board of Selectmen, acting as park commissioners, have reviewed and approved the OAA's plans for the renovation and expansion of the present building and would respectfully request your favorable consideration for this worthwhile project. Very truly yours, John Kelly. So we've received the good graces of the Board of Selectmen. I have appeared before the Architectural Review Committee. They have approved the plans, and I have appeared before site plan review, and they have approved the structure. So with that being said, I would respectfully request that you grant a variance for the addition to the home plate shop and souvenir, the souvenir shop and announcer's booth.
Very well. Since you're applying for a variance, you propose that the variance is justified for hardship because the existing structure needs to be expanded and it's necessary it remains located behind home plate and the backstop. That
Yes, sir.
means there's no other place for it.
Absolutely.
Concerning soil conditions, shape, and topography, your justification is the shape of Eldridge Park and the location of the existing playing field allow for no other possible location. That's a variation of what we just said before, right?
Yes, sir.
And the impact to the public good and the intent of the chapter, which is General Laws, Chapter 40A, Section 10, is that the renovated and enlarged press box and souvenir shop will provide a safer and better structure for the OAA and the Orleans Firebirds to use and in turn provide a service from which thousands of people derive benefit every summer, something which no one can really question. Those are the reasons for the variance. If we're favored with the benefit of two previous decisions, at least one of which was for a variance.
Irregular lot shape, for that hardship?
I think the combination of the lot shape and the fact that the ball field is located where it is, the combination of the two, yes, I would think so.
In 2003, I think the new press box was originally constructed, and on that occasion, on April 2nd, this board gave a variance to run with the land as long as the property is being used as a baseball field. There's no question about that. So this is principally an extension of what was really done once before and determined in 2003. Just my translation of my thinking on it anyway. Is there anyone in opposition who wishes to speak in opposition to this application for a variance? And are there any questions from any members of the board or commentary for that matter?
Question? Will the sign that says that the next game will be, Tuesday at 7 p.m. continue to hang on the side? It's always been a good reminder for me of when there's a game.
I would expect so, and this is a copy of the sign that will appear on the side that faces the road that was approved by the Architectural Review Committee.
That sign is, that when the game's going to be, is at the corner now, isn't it? At the corner of
There's one
Eldridge?
at the corner, and they also put it on the building. They have a little ladder sign that they have on the building.
Yeah, as you come down past the school, you see it on the...
I never noticed that.
Should be some notation about the tragedy of it no longer being the Cardinals, but that's a different story.
We have the Major League Baseball to thank for that.
Bought a Cardinals hat first year I moved here, and it was the next year they made them change it.
The OAA They are applying for a grant, which they expect to receive in June, which will cover the cost of the entire renovation. And they hope to start construction in September after the baseball season's over.
So we're looking at the work being done, finished a year and a half from now.
I didn't even know there was a souvenir shop in there.
Now it'll be a well-publicized souvenir shop. Seems to me, I once had to drive to Eastham to get one of my grandsons a Firebirds t-shirt. Somebody had them up there. Are there any other questions for Mr. Little? Then I propose that following public deliberation by the Zoning Board of Appeals, a quorum of qualified members being present and voting based on the application of the Orleans Athletic Association on behalf of the Eldridge Field, based also on the site plan actually certified plot plan drawn by Ryder and Wilcox, dated December 19th, 2013, and based also on the drawings showing the proposed renovation, 2 pages, and the plan entitled New Revised First Floor Layout, Orleans Firebirds Home Plate Shop Edition, dated October 8, 2013, drawn by the Richard L. Marangel architect, and based also on the letter of John F. Kelly on behalf of the Board of Selectmen recommending approval. I move that the board adopt the following findings of fact: that a variance is required to allow for the expansion of the existing press box and souvenir shop at Eldridge Park within 25 feet of Route 28. 2, that the...
Mr. Chairman?
Yes.
It's actually, the variance is for relief to the side property line. We're not getting any closer to Route 28.
Oh, I thought you were. Then, the variance then is only for, it says in your application, it does refer to 19.6 front setback, Mr. Little.
Well, I provided you with all the dimensional criteria.
Yep.
But specifically, the variance is for increasing the nonconformity to the northerly side property line. We're not becoming any more nonconforming to the street.
Now, then I'm going to revoke that finding until I clarify it. Oh.
Pre-existing.
19, find that the variance relates to an intensification of the nonconformity from 19.2 feet on the side yard to 10.4 feet.
number next in order, that the existing structure needs to be expanded, and the press box has to remain located behind home plate in the backstop where it's historically been located and where it makes sense to be located. And the number next in order in the findings is the shape of the park. The location of the existing playing field allow for no other possible location of the press box and souvenir shop. And finally, a finding that the renovated and enlarged press box and souvenir shop will provide a safer and better structure for the Orleans Athletic Association or its successor and the Orleans Firebirds to use, and provide a service from which thousands of people derive benefit from every summer. That concludes the motion. Do I hear a second?
Second.
Very well. Is there any discussion on the motion? All those in favor?
Aye.
And opposed? None. The motion carries unanimously. Then therefore, I move that a variance be granted to run with the land to the Orleans Athletic Association to reposition and replace the existing press box and souvenir shop.
Second.
And any discussion on the motion? All those in favor?
Aye.
And opposed? The motion carries unanimously. Thank you, Mr. Little.
Thank you.
Thank you for your patience, and
And thank you for coming, Ralph.
is there any further business to come before the meeting? Then I'll entertain a motion to adjourn.
Motion.
And a second?
Second.
All those in favor? Aye. And no opposition. The motion is carried unanimously. Thank you, Rolf. I appreciate it.
So,